Mr. Apjohn? Good morning.
Good morning.
Good, thank you. You may proceed.
May it please the Court, my name is Nelson Apjohn, and together with Attorney Donahue, I represent the defendant appellant, the Commerce Insurance Company. The issue before the Court on further appellate review today is one of statutory construction. In particular, the question is, does General Laws Chapter 90, Section 34M, prevent an insurer from refusing to pay medical benefits as claimed personal injury protection benefits based upon a physical examination of the claimant done by a practitioner under a specialty other than that of the billing practitioner? Our position is that there is no such prohibition in Section 34M. The facts and procedure before we came here today are relatively brief. Mr. Boone was injured in an accident. He received chiropractic care. Commerce paid for that care as personal injury protection benefits. It requested a physical examination under paragraph 3 of Section 34M. The orthopedic surgeon who conducted that examination found that Mr. Boone was at an end result, that further treatment was not necessary. Commerce informed Mr. Boone that it would no longer pay for chiropractic treatment, and Mr. Boone continued to treat for approximately 9 months and then sought recovery of those bills in the district court initially.
So your construction of the statute would be, well, first of all, the independent medical exam is, I think it's the paragraph before this paragraph.
Yes, paragraph
right?
3, Your Honor.
And insurers have an absolute right to have a claimant undergo an independent medical exam.
That is correct.
So it doesn't seem to make much sense if you can have an independent medical exam to say in the next paragraph, you got to pay all the bills that someone else puts in if the medical exam determines they're not necessary.
That's exactly correct, Your Honor, because the statute says in the 4th paragraph where the review is based solely on the review of the medical bill or the medical services underlying the bill, physical exams are dealt with in
So the
paragraph
review of
3.
the bill, in your opinion, I guess, would be for purposes of payment only. In other words, if you say, well, this chiropractor is charging too much, another chiropractor would have to look at it to say, no, these are reasonable chiropractic charges.
That's correct. Typically, a review of the bill would be, are the
Right.
charges reasonable?
But explain to me, what is a medical review of the medical services underlying the bill, and why doesn't that include a medical examination of the plaintiff?
For a number of reasons. First of all, review of medical services would typically be a review of the records of treatment.
And where do we get that from?
Well, I think the most important point is that a review of a bill or a review of services is not a physical exam of a patient. And we get that from a number of places. First of all, physical exam is dealt with in paragraph number 3. That language, if it was intended to be used by the legislature in paragraph 4, would have been used. This court has held before in the Polson case that where specific language is used earlier in the statute and not in the later part, the court will not apply it where it does not exist. Number 2, from the specific legislative history involved here, this amendment, the so-called same profession requirement, was added in 1989. At that time, when it was going through the legislature, it specifically said the same profession requirement did apply to independent medical examinations and also medical reviews. But when it was finally enacted, independent medical examinations, that language was taken from the amendment. Now it's as worded in paragraph 4. So the legislature distinguished between exams of persons and medical review of claims when it enacted in 1989 the amendment that we're dealing with here today.
I take it, Mr. Sorry, Judge Boston.
Well, I take it that if you, I mean, you could posit, and this is, I think the way you can distinguish these things, you could posit somebody looking at, an insurer looking at the fact of having chiropractic services for this particular injury based on the medical records. And it seems to me what that 4th paragraph is saying is you can't deny payment unless somebody physically, a chiropractor, another chiropractor looks at that and says, yes or no, those were services necessary, but it's still paper.
Right. And think about the implications of the appeals court decision. You have a medical examination by a physician, an orthopedic surgeon, who typically deals with issues of causation. The orthopedic surgeon says that this particular back pain is not related to an accident. It's related by degenerative disc disease. It has nothing to do with this. Under the appeals court decision, now do you have to bring in the physical therapist and the chiropractor, who typically are not in the position to give an opinion on causation, and say, well, no, these are not necessary. What are they going to look at? They're going to look at the orthopedic report. It's just an addition of an unnecessary expense, not only a duplicative expense, but completely unnecessary because
Mr.
the
Mully,
chiropractor will not be able to deal with this.
excuse me, even before we get to there, one of my problems with the appeals court decision is it starts from the proposition that the language is clear and ambiguous. But we have two judges who've come to exactly the opposite. I mean, it can't be clear and unambiguous when you've got decisions in the Superior Court that go in exactly the opposite direction, when there's language in our formal opinion which is exactly contrary to this. I mean, at very minimum, this language is not clear and unambiguous.
Well, I think as the courts in the Medicare case, when you look at the words of the statute, you look both at the literal meaning and also the purpose and history of that statute. And here, that's dealt with in the Galena case, an appellate division decision, that it specifically looked at the amendment. As I said before, by the time it got out of the legislative process and was finally enacted, the term independent medical examination was removed from Section 4, as that language is now contained.
But would it be sensible, would it be logical to say that clerical people can allow the claim, but when there's going to be a denial, there must be a review by a doctor of the same specialty? That would be a logical way of reading it, wouldn't it?
Well, if you have an independent medical examination, I think in that situation, if an orthopedic surgeon says there's no causation, I don't think at that situation you have to bring in the chiropractor, the acupuncturist, the pharmacist to say, yes, I agree with the orthopedic surgeon. They're not even in a position to give a causation opinion.
But that's not what's going on here. The orthopedic
that's
surgeon here is not saying this wasn't causation. They're saying that, well, they reached a final resolution.
Right, and that further treatment's not necessary.
Okay.
So
It's not
on
an
the
issue
on
of
the basis that-
causation here.
But it could be. Is this-
this was not a...
No, this wasn't.
In this particular case, as Justice Cordy said, the orthopedic surgeon said that Mr. Boone was at an end result. Further treatment was not necessary.
And therefore, the insurance company declined to pay the chiropractic bills that had been accumulating, or was it prospective? Declined to pay any
bills
future
after the
ones?
examination. They pay the bills up to the point of the examination. It was looking forward.
Well, that is sort of a causation thing, in the sense that the accident has no longer caused the need for any further medical services.
Well, that's correct.
But you could also have a causation case.
Yeah.
In other words, somebody could go to a chiropractor, for whatever reasons, because there is, some stiffness or something or other, the insurance company decides that it'll pay the bills initially, even though it has its reservations. I mean, it's got all kinds of, consumer protection threats hanging over its head, and then it says after 6 months or a year, I want to have somebody come back in. And the second independent medical examination says that there's actually no causation.
And I think that's an important point. The person chosen for the independent medical examination should be based on the nature of the injury and the issue involved. It shouldn't be based on who is submitting bills for treatment.
Mr. Mully, could I just have a follow-up question? In the wake of an accident, of an automobile accident, would your client be paying, for example, psychiatric and psychology bills properly submitted?
Yes, I believe those are reimbursed.
Do you make anything of the fact that in paragraph 3, the word uses physicians? I mean, in the briefs, there's a lot of back and forth about dental. Somebody would. Does it matter? I mean, what do you do about that?
There's at least one case, I believe it's a appellate division case, that said, even though that said physician, you can read that to say chiropractor as well. So, for example,
Or any medical or healthcare professional, is that?
I guess licensed under 112, Chapter 112. And I think in that particular situation, there's a claim made in the opposing brief that somehow we're saying an orthopedic surgeon can render an opinion on a dental issue. That's not what we're saying.
No, of course not. I mean, that is to say, I think
Well,
there
that
would be a
makes no
reasonable
sense.
basis for challenging if it was a completely,
You'd have to have the independent medical examiner, et cetera, and so forth, be in the same general area
That's correct.
of medical practice.
But that would be true of the first time the insurer uses an independent medical examiner. In other words, if the claimant is claiming, I was injured and I have back stress or shoulder stress, or I mean very serious things, or my elbow doesn't work, I don't think having an oncologist look at that would be particularly helpful.
Right.
What's the review of saying that this is an unfair evaluation, I assume, under the normal protection statutes?
Well, what the appeals court held here in the court below is they said since you did not use the same practitioner under the same specialty as the chiropractor when you did the independent medical examination, you had to basically ignore your orthopedic examination and go out and get a chiropractor to also render an opinion, which was really contrary to just the general purpose of the automobile insurance.
But the question I think the Chief is asking is, let's assume your reading is acceptable. What if the insurer used for the independent medical examiner an oncologist where the problem is a back injury? I mean, just what if? But how does that insured get relief from that problem?
Well, I think in that situation, and first of all, the people dealing with this, of course, are doing claims for a living. So they know that they have to have an opinion that, if challenged, is going to hold up in court. So
what's the root of challenge?
the challenge is, as it happened below, where Commerce denied payment after the orthopedic examination and suit was commenced to recover those costs. And in that situation, the court said, since you didn't, at least the district court judge agreed with Commerce, the Superior Court judge disagreed and said, since you did not use the same specialty, you violated 93A.
Well, the appellate division, in the Galena case, came out exactly the opposite way.
Yes, Your Honor.
So it's not just the district court judge; it's the appellate division, of the district court.
Yes, there's opinions going both ways. And in Galena, they also looked at the clear and unambiguous language and said there's no same profession requirement, but also look at the legislative history in 1989, and you can see that the legislature removed the requirement for same specialty for independent medical examinations.
I can't recall. Did the appeals court deal with Galena?
No, Your Honor.
Had Galena been decided by then?
Yes.
It's 2001, yeah. So it just ignored it?
Yeah, the appeals court basically took the position that the same specialty requirement applied to any medical review of PIP claim, whether it involved a examination or not. In our position, and I think under the statutory language, you don't even reach the word claim in that sentence unless you get past solely based on a medical review of the bill or the medical records underlying the bill. So on the plain language, we believe the appeals court is wrong. But also, if you look at the specific legislative history, it's quite clear that they've incorrectly construed that statute, that the interpretation, our interpretation, has been confirmed by the legislative history. And also, as I mentioned, the general legislative history with respect to the automobile insurance laws is to control the cost of insurance, to reduce tort suits, and also, of course, to prompt payment with respect to out-of-pocket cost. And here we are adding additional layers of medical providers. And if you look at the IAB brief, in 206, at least 1/3 of claimants were treating with multiple providers. So you're adding a whole cost to the system that's unnecessary. And as I mentioned before, in situations where you're asking an acupuncturist to look at the work of an orthopedic surgeon on causation, it really makes no practical sense whatsoever. So for that reason, because we believe that the plain language of the statute is contrary to the interpretation advanced by Mr. Boone and affirmed by the appeals court, the appeals court opinion is contrary to the specific legislative history with respect to the 4th paragraph of 34M. It's also contrary to the general purpose of the automobile insurance laws in Massachusetts. We ask that the court reverse the judgment below and enter judgment in favor of Commerce Insurance Company. I don't know if there's any other questions.
Thank you, Mr. Aptron. I do realize that you are Mr. Aptron and not Mr. Murray. So, Mr. Murray, I'm not going to be calling you Mr. Aptron, I hope.
Thank you, Your Honor.
Mr. Murray.
Thank you very much. And for the record, I am, in fact, Mr. Murray. I appreciate the opportunity to be before the court and make the presentation on an issue that is probably more troublesome on paper than it is in practice, because as a practitioner I can say to you, at least within the last 5 to 10 years, my experience has not been that this has been an issue, because the insurance companies have been getting IMEs from doctors in the same practitioner.
But this case calls into issue the classic confrontation between chiropractors and orthopedic surgeons.
It does in one sense, but I would hesitate for the court to focus on that conflict between chiropractors and surgeons, because there are other areas. And in the terms of dental injuries, for example, I mean, I'm not, presenting in the brief the classic dental injury where teeth get knocked out, but there are TMJ cases which overlap with orthopedic treatment. There are cases where plaintiffs, claimants might treat with psychologists for post-traumatic stress syndrome. And all of these other areas do come into play in the interpretation of the statute. Commerce has focused solely on the chiropractor-physician conflict, and I think the question is much more broader than that.
Mr. Murray, could you help me out? One is, particularly in light of the Galeno opinion, which is not a single trial judge, but it was a considered opinion by a panel of judges, an appellate decision, goes exactly the opposite way. So I can't start from the proposition that this language is unambiguous. I therefore, under normal rules, go to the statutory history, and the statutory history seems absolutely clear, because in the original proposal, in the House proposal, it used the words of the same specialty license to practice, and then went to the governor. The governor refused to sign it. It came back again, and they took those words out. I mean, what am I supposed to do with that?
Your Honor, in terms of the Galena decision, let me just make a couple of points.
Sure.
First of all, I would not submit to the court that the appeals court ignored the Galena decision. If you look at the Galena decision closely, I would submit to the court that the Galena decision takes assumptions and goes leaps and bounds over what the statutory language actually says. The Galena decision talks about the statutory language as medical records review, and the appeals court explicitly stated that the word records nowhere appears in Section 34M in the fourth paragraph. The Galena decision also only talked about submitting bills for review. It ignored the much broader language that the statute talks about submitting the entire claim for review.
No, I understand the reasoning, but nevertheless, I mean, the point under review in the Galena decision was this very point. I mean, you may disagree with the decision.
Absolutely, Your Honor, as it was in the Boone appellate division case, which was in direct contravention of what the Galena decision was. I think my point for the court is a close reading of the Galena decision says that the Galena decision took some assumptions about what the statute says that it doesn't actually say. In terms of the legislative history, I think that's very interesting, and it's probably one of the first chances I've had to really kind of dissect a statute and look back on it. There's no question that the original, bill was entitled Independent Medical Examinations. But I think it's key for the court to actually read the language of that first proposal. And I quote, "Any IME or medical claim review requested by an insurer shall be conducted only by a licensed practitioner of the same specialty licensed to practice as such under provisions of Chapter 112. I would submit to the court that that original amendment, that original bill, is quite confusing and quite open. The same specialty as whom? I think it's also significant that that original bill was proposed as a new section under Chapter 90, Section 8C and 1/2, which, I mean, I looked up 8C, and it has something to do with medical advisory boards, with learner's permits, totally unrelated to the no-fault benefit statute of Section 34M.
Didn't that ultimately, maybe I'm incorrect here, but didn't this, the House proposal, which was rejected by the governor, and then as amended by the Senate in June 1989, didn't they take the text and stick it into 34M?
Actually, it was totally rewritten. The actual amendment that got passed as the fourth paragraph of Section 34M is entirely different from the text that was originally proposed under Section 8C and 1/2.
Sure.
And the argument that I would ask the court to consider, as I made in my brief, I think there's well evidence that the legislature intended this language to apply to independent medical examinations by placing it in Section 34M, the paragraph directly after independent medical examinations in paragraph 3.
But wasn't it placed in there without the language about independent medical examination?
It was, and I think that's a very significant point also, because that brings you back to the terminology which I would submit to the court is the key language for this court to focus on, the part of Section 34M that talks about a medical review of the bill or medical services underlying the bill. Now, all of the work that's been done on this case by myself, by Commerce's counsel, there's only one case out there that was submitted that actually tries to define that language, and that's the Miller case. It's a 1998 appellate division case, and it's clear in the Miller case that that language, medical review of a bill or medical services underlying the bill, includes an independent medical examination. So my argument to the court would be the legislature enacted the amendment to 34M with language broad enough to include independent medical exams as well as other reviews that the insurer may request. And by doing that, it put the limiting language that the review must be from a practitioner similarly registered.
What do you say to Mr. Apjohn's hypothetical about an issue where the reason the insurer is not paying for continued services is it has an orthopedic surgeon who says this isn't, causation is the issue. Isn't it the case that the chiropractor or the physical therapist or whomever isn't really in a position to talk about causation?
Which one, the examining
I'm using Mr. Apjohn's example that if
Okay.
you have chiropractic services
Yes.
that you're seeking payment for, and there's an IME by an orthopedic surgeon who says you don't need these chiropractic services because the condition wasn't caused by the accident. It's a degenerative disc disease or whatever. So I'm just asking if your reading of fourth paragraph is that these bills need to be reviewed by a chiropractor, correct? And why is the chiropractor in a position to say whether the services are, whether this condition was or was not causally related to the accident?
I would submit to the court that basic fairness, the chiropractor would be in the same situation as the treating chiropractor and would be most qualified to comment upon the claimant's injuries and the extent of chiropractic treatment.
But I think the question is a chiropractor qualified as an expert to give an opinion on causation in court?
I believe yes, and the plaintiff similarly could use a chiropractor's opinion if he or she so choose to do so as the treating physician to go forward. But I can say this, what will happen is the battle of the doctors. If the insurance company gets a physician who is not similarly registered as the treating physician, there's no question that that's only going to lead to more litigation. Because now there's going to be a fight about payment of the PIP bills. And the claimant is going to say, hey, I've submitted my bills, and it's a chiropractor or a dentist or a psychologist or whatever.
Help me out a little bit. Are PIP bills capped at any amount?
They are. If the person...
Is it like 7,000 or something?
2 and then 8.
Right. If the claimant has private health insurance, then PIP only covers the first $2,000.
Have that case on later this week.
Yes.
Oh, okay. All right.
You might want to watch that argument.
I don't want to handle any more cases than I have to. If there's no private health insurance, the PIPs are capped at $8,000.
Did you do any research to see if we took this statute in whole or in part from any other state? And if so, how they may have construed this provision?
I have not, and I don't know of any. We were not submitted anything. I mean,
I think the Massachusetts PIP statute is sui generis.
Unfortunately, yes.
Good for lawyers.
As I recall it, the whole scheme, with no-fault scheme, which of course this is, was borrowed from Wisconsin.
It may have been. I think the original no-fault law was passed in the early 70s.
Correct.
This amendment that we're talking about came on board, I think, in the late 80s. I mean, you know, I have my personal opinions about the no-fault law, just simply being a practitioner dealing with it day to day. If it was designed to decrease cost and decrease litigation, boy, it's been a failure, because the amount of cases that have been generated out of PIP and no fault are far in excess of any tort issues that may exist. That's an aside. That's
Mr. Murray, could I just go back to your statement that it would lead, you know, if you had an orthopedic physician versus a chiropractor, or a psychiatrist versus a psychologist, which would be another classic, sort of in the same field, but one is an MD and the other one isn't. Why would that lead to more battles than a chiropractor versus a chiropractor, a psychologist versus a psychologist?
because it would give the claimants, it would give plaintiffs grist to go forward to challenge the denial of the insurer. There's no question about that.
Why let's assume, and I'm not suggesting we will, let's assume that we rule in favor of commerce, and so the rules are clear that you can use, you know, somebody in a like specialty.
Now you'll have the battle of the experts.
Yeah, but don't you have the battle of the experts in chiropractor against chiropractor?
You may, but the plaintiff has one less weapon in his or her arsenal to attack the insurer's decision.
Mr. Murray, don't you think as a practical matter that if you were a reasonable insurance company, and I understand you may say that that's an oxymoron, but let's just assume that there is a reasonable insurance company, wouldn't they be likely, outside of this chiropractor orthopedic surgeon conflict, to pick for the IME person someone in the same field just to avoid just what you're saying?
There's no question about that, and that has exactly been my experience in the personal injury field, I would say at least for the last 5 years, maybe even longer than that. To me, on a practical level, this is not an issue because the insurers are adhering to the fourth paragraph of 34M. The sea,
whatever reason.
I'm sorry. The sea of practitioners willing to examine a claimant and render a decision to the insurers is large enough for the insurers to fish very liberally and provide that kind of opinion. So to me, on a practical level, I don't see this as an issue. I think the understanding I have from Commerce's point of view is that there are cases in the pipeline that may have been handled differently. Maybe, you know, a number of years ago, I would suggest to the court that, you know, I'm certainly asking for the court to uphold the appeals decision and make it prospective from any claims here and on after.
What do you mean make it prospective?
The holding would apply to cases, to claims made after the decision of this court because of a potential uncertainty. That might satisfy Commerce's or the insurance industry's concerns that there may be cases out there which might require multiple IMEs. And just on that point, because I know one of the insurance industries filed a brief and gave a cost to the industry, said the cost was about $9 million for the year 2006 to the entire insurance industry. And of that IME expense, approximately 1/3 claimants would go to more than one practitioner, and it could increase cost to the insurance industry system to the extent of $3 million. I would submit to the court, no one is looking to increase costs, but that number needs to be in perspective. And in July of last year, the Hanover Insurance Group, which is one of the companies that filed a brief here, reported a net increase on a quarterly basis of $59.8 million. That's one company, 1 quarter, $59.8 million. Now, I only say that number for the court to consider the proposed costs that the insurers have submitted to you in context.
Thank you, Mr. Murray.
Thank you very much for your time. I've appreciated it.